All right, today we're diving into a legal and social saga that really spans decades. It's a story about two women, two really powerful cases, and how their individual fights for justice completely reshaped the landscape of personal law here in India.
It all kicked off with something that sounds pretty simple. It was just one woman's plea for maintenance, a divorced woman just asking for some financial support from her ex-husband. A private matter, you'd think, but it was about to become very public.
And that simple plea, well, it ended, decades later, with a law that actually criminalized a 1,400-year-old practice. So what happened in between? How did we get from a private dispute over alimony to this massive nationwide debate on religion, law, and women's rights? Let's dig in and find out. So let's start at the beginning. Our story really kicks off in the late 1970s with a woman named Shayara Bano. In her case, wow, it was the spark that ignited a firestorm of debate across the country about personal law, secularism, and the rights of women.
Okay, so if you look at the timeline here, you can see just how quickly things escalated. It's pretty dramatic. In 1978, Shayara Bano, who was 62 at the time, gets divorced, and she seeks maintenance. She does this under Section 125 of the Criminal Procedure Code. And this is key. It's a secular law that's supposed to apply to every citizen, no matter their religion. By 1985, the Supreme Court rules completely in her favor. But then, the political backlash was just so huge that only a year later, in 1986, Parliament steps in and passes a brand new act.
Yeah, so that Supreme Court verdict, it wasn't just about maintenance money. No, it touched a really raw nerve in Indian politics. It was like it ripped open this huge debate, pitting these core constitutional principles against religious personal laws.
And the court didn't just stop there. They went beyond Shayara Bano's specific situation. They actually brought up Article 44 of the Constitution, which is the part that calls for a uniform civil code for the whole country. And by doing that, they basically said, hey, look, this case right here, this is exactly why we need a common civil code. They called Article 44 a dead letter, which, as you can imagine, just poured gasoline on the fire. So with all that political pressure, the government passed a new law in 1986, the Muslim Women Act. And what it did was basically dilute that Supreme Court verdict. It limited a husband's duty to pay maintenance to just the iddat period. That's about 3 months. After that, the financial responsibility fell to her family or a local trust. So this huge underlying conflict between secular law and personal law, it was just left hanging. So for about 3 decades, things went kind of quiet on this front. The issue was just dormant. But then, fast forward to 2016, a new fight, a new woman, Shayara Bano. She didn't just reignite the debate. She brought a direct challenge that was going to force this whole issue of personal law versus constitutional rights right back into the spotlight. So Shayara Bano's fight was centered on a very specific practice, talaq-e-bidat. You've probably heard it called instant triple talaq. And let's be really clear about what this is. It's a practice where a Muslim man can instantly and irrevocably divorce his wife just by saying the word talaq 3 times. In one go. And that's it. Marriage over, no chance for reconciliation. And this is exactly what happened to Shayara Bano. After 15 years of marriage, she was divorced just like that. But here's the thing. She didn't just fight back against her own divorce. Her petition in the Supreme Court went way bigger. She challenged the constitutionality of not just triple talaq, but also polygamy and another practice called nikah halala. So her case was asking this massive question. Can these personal law practices really be exempt from the fundamental rights that the Constitution promises every citizen? And that, right there, set the stage for a monumental legal battle. It really forced the Supreme Court to wade into these incredibly complex, murky waters. The relationship between the Constitution and religious personal laws. The core arguments were, as you can imagine, worlds apart. On one side, you had Shayara Bano's lawyers arguing that this practice is discriminatory, it's arbitrary, and it violates fundamental rights to equality, non-discrimination, and just life and dignity. They said it's not even an essential part of the religion. But on the other side, the argument was that personal laws are completely separate from the Constitution. They're protected by the freedom of religion, and courts shouldn't be reviewing them at all. It's a classic clash.
So, after all the arguments, all the debates, it all came down to one day. August 22, 2017. A 5-judge bench of the Supreme Court was ready to deliver its landmark judgment.
But here's the kicker. It wasn't a clean sweep. The final verdict came down to a razor-thin 3-2 split.
And that alone just shows you how deeply divided the legal opinions were, even at the highest level.
So let's look at the majority opinion. The 3 judges who voted to strike it down had a few key reasons. First, they said triple talaq is not an essential part of the Islamic religion, so it's not protected by freedom of religion. They also called the practice manifestly arbitrary. I mean, it lets a man end a marriage on a whim. Because of that, they said it violates Article 14, the right to equality. And one of the judges came out with this incredible line: "What is bad in theology cannot be good in law."
But then you have the minority opinion, right? The 2 judges who dissented. They saw it completely differently. They argued that personal law is an essential part of religion, and it's protected under Article 25. They basically said, look, it is not the court's job to interfere in matters of faith. If this practice needs to be reformed, that's a job for the legislature, for Parliament, not for us judges.
And, well, wouldn't you know it, that's exactly what happened next. The Supreme Court's verdict struck down the practice, but the story wasn't over. That call for the legislature to act, it was answered.
So in 2019, Parliament passed the Muslim Women Act, and this law went even further than the court's judgment. It first declared that pronouncing triple talaq is void and illegal, but then, and this is the huge step, it made the practice a criminal offense. We're talking imprisonment of up to 3 years for a man who does it.
And so, here we are, right back where we started in a way. This whole journey, from Shayara Bano's plea for maintenance all the way to the criminalization of triple talaq, it brings the debate right back to that fundamental question the Supreme Court asked back in 1985. With so many different personal laws, how do you balance religious freedom with that constitutional promise of equality for everyone? It's a tension that continues today, and the conversation, well, it's far from over.